The best thing that happened to me in my child support hearing is that I didn't have the money to afford an attorney. That's the best thing that happened to me. Why? Because had I hired the attorney, I would have made a general appearance, which means I would have recognized the authority of the court, and I would have waived any of my rights to challenge.
How do you actually get a judge removed from your case if they just keep denying your motions? So let's run through it. Here's how I do it. If I file a motion to dismiss and I outline the law, the statutes, and the case law, and the judge ignores his oath to the Constitution and he denies it, that's when I turn up the heat. I send that judge a notice of claim, also called a letter of intent. This is the first step in the lawsuit process. In that letter, I inform the judge that he's violated my constitutional rights. And if this issue isn't resolved, I plan to sue him in federal court. Now here's why this matters. Under Judiciary Law 14, a judge who has a conflict of interest or even the appearance of partiality is supposed to recuse themselves. So once you've served the notice of claim, the judge is essentially your future opponent in federal court. He can't fairly preside over your case while being a defendant. If the judge is honorable, he'll step aside. If he refuses and keeps your case, then he's forcing you into a situation where your federal opponent is still sitting in judgment over you. That's a due process violation, plain and simple. So remember this, a notice of claim isn't just a warning. It's the first legal step towards a federal lawsuit. Once it's filed, the judge has to choose, recuse himself or violate the appearance of fairness that the law requires. If you want my exact template letters for notice of claim letters and motion to recuse that you can adapt for your own case, drop a comment saying fight back and check your inbox ASAP. I got you. Let's get it, y'all. Get those unfair judges off of your case. Stop letting them play with you. Stop letting them play with your kids. Let's get it, fathers.
Yo, what's poppin', family? I wanted to do this quick and give a shout out to Dev. He laid out information. I had child support hit me, started garnishing my wages immediately. I applied what he was teaching, managed to get a court date. Because I was getting the game, I managed to make it through court date, and now child support's been terminated, and they're paying me back with their refunding me from the funds that they've took. You know, so I want to give a shout out to Dale. Appreciate you, King.
If you want to sue child support, it's very simple. Know what it is that you are asking for. Like, how much money do you want? You have to know exactly who it is that you want to sue. Are you suing a child support agency? Are you suing the magistrate? Are you suing the DMV for suspending your license? You understand me? Are you suing your employer for garnishing your wages, knowing that they're incentivized to do so? Yes, that's what I'm saying. You can sue for all these different reasons. And sometimes a lawsuit is as simple as filing the paperwork and allowing the other party to come back. Now, you got to remember this as well. It's a lawsuit, so that means it's a fight. These people will come back at you. They'll put in a motion to dismiss your whole case. Do you know what to do after that to overcome that? It's all about the knowledge, King.
Yo, you should never hear something on Instagram, then run to court with it like it's a magic spell. Because real talk, social media is not your case file. Instagram is general game, not your specific facts. In child support court, the judge doesn't care what worked for somebody else if you can't prove that it applies to you. Here's why Instagram advice can backfire. Number one, every state has different rules. Deadlines, service requirements, hearing procedures, even motion standards. What's valid in one state can get you embarrassed in another. Number two, a good argument could be a bad move if you use it wrong. You could accidentally admit to jurisdiction, or you could waive the defect service. You could file a wrong motion at the wrong time and lock yourself into the court's process. Number three, you don't know what that person didn't tell you. A lot of viral advice skips the boring parts. They skip the record, the evidence, the local court rules, and the exact wording that's needed to protect your rights. Number 4, the courts only respect what's supported. They don't care about vibes and a good caption. They don't care about screenshots. If you can't cite the rule and then show the proof and connect it to your facts, it's just noise. Instagram is just a starting point for your awareness. But researching a good strategy, that is what wins cases. If you want help breaking down your case, building your plan, and using the right tools at the right time, go ahead and comment the word consultation. At least get a feel for what it is I can offer for you. And then that way you can go into the court with something workable, something that you can actually use.
Are you Michael Williams?
Yes.
You've been served.
Stop right there. Stop right there. This moment is called service of process. If this didn't happen to you, your child support case could be void. The law is clear. Family Court Act 427 requires a summons to be served at least 8 days before the hearing. If the court can't prove that service, then they never had jurisdiction over you. CPLR 308 lays out exactly how you must be served. 1. Personal delivery to you directly. 2. Delivery to a person of a suitable age at your home, and mailing. So they gotta mail it too. Then they have a nail-in mail, which is posting on your door and mailing. So if they leave it on your door, they gotta mail it. Or a court-approved alternate service only if the first 3 options fail. Anything else is invalid. So if they didn't do it that way, it's invalid. If they only mailed the papers or dropped them at your job or gave them to some random, that's not legal service under CPLR 308. And without signed affidavit of service on file, there's no jurisdiction. The order can be challenged as void ab initio, meaning it was never valid from the start. So here's the power move. Go to family court clerk, request your certified copies of your original case filings, including an affidavit of service. If they can't produce it, or if it doesn't meet the FCA 427 and CPLR 308 requirements, you have grounds to demand dismissal. Demand dismissal, it's your right. I created some court-ready template letters citing all the laws. It's the same ones that fathers are using to fight back now. So if you want help, comment template below. I'm gonna send you the paperwork so you can have the authority in your hands, okay?
They not like us. 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 You think the bank gon' let you disrespect Pop, nigga? I think that Oakland show gon' be your last stop, nigga. They cold foul. I don't know why you still pretending. What is the owl? Bird niggas and bird bitches. Go. The audience not dumb. Shape the stories how you want. Hey Drake, they're not slow.
Listen, y'all. Now, I already showed y'all how to file motions and what to do before you get to court. Now I want to teach y'all exactly what to do and say once you're in court. So let's work on your opening statement. So once you're in court, you already bought my template letters. You already submitted the motions. Everything is a go. You got a court date. Now it's time to appear in court. What do you do in court? What do you say? Well, what I suggest is that you come prepared. You already have your opening statement ready. You already have your rebuttals ready because we already know what they're going to say. So we come prepared. That way you have maximum confidence when you're in there. You're not fumbling over words and stuff. You can read off your script and you know exactly what to say. It's on the record. That's how you're going to go into court and attack them and fight the case. So let's start with the opening statement. Here's what you're going to say in court. Once you get into court and the judge is asking you, okay, so why are we here today? This is going to be the opening statement, something along the lines of this. This is for educational purposes only. This is not legal advice. Your Honor, I'm here today on a special appearance only, pursuant to CPLR 320B. I am not making a general appearance, and I am not waiving any constitutional objections. The purpose of this hearing is to challenge jurisdiction. Before the court could take any action, enter any orders or move forward with any support-related matters, the court must first prove that it obtained personal jurisdiction over me through lawful service, as required under CPLR 308, FCA 427, and 28 USC 1691, as reflected in my filings. I am requesting that the court produce the original sworn affidavit of service from the alleged date of service showing who allegedly served me, the exact method used, the date, time, and location, and the signed proof filed with the clerk's office, as mandated under 22 NY CRR 205.11. To date, no such lawful service appears in the record as established in Trackman v. Kenny and matter of Smith v. Smith. Absent proper service, the court lacks jurisdiction and any order issued is void ab initio. I am preserving my objection under CPLR 5015 A4, which makes it clear that a void order must be vacated at any time, even years later, without a deadline. So I'm asking the court, if you cannot produce I'm a gorilla in a fucking scoop, gonna pull up to the zoo.
And this is episode 2. Every last child support case can be terminated, and you can do it without a lawyer. If this one step didn't happen, your child support order was void. Not unfair, not incorrect, void. That means it never legally existed, no matter how many years you've been paying on it or supposed to pay on it. And yes, you can challenge it today. The entire system hinges on one requirement. You must be served properly. Not told about it, not text, not hinted, not I think you knew, not mailed unless you signed for it. If the court never got jurisdiction over you, the court never had the authority to issue an order. Penal versus Neff is still law today. No service equals no jurisdiction. You also got cases like Mullane versus Central Hanover Bank, which says that notice must be reasonably calculated to reach you. Peralta versus Heights says you're entitled to a hearing before they can even take your money. What are we talking about? I had a father in Michigan who had been paying child support for about 7 years. They garnished him, they hid his tax returns, his license got suspended, but guess what? He was never served properly. He didn't know nothing about that until he got in touch with me. We went and pulled his proof of service and we found out, whoa, it was fake. There was no signatures. He didn't sign for it and it wasn't even notarized by the courts. His entire order was void from day one. So of course we challenged the validity of the order and he was able to walk away with his case terminated and $40,000 in arrears gone. The system counts on you never checking that page. They hope you never ask, who served me? When did they serve me? Where? How? Do I recognize this signature? Because once you ask those questions, the whole case collapses. So I want you to do this right now. First of all, go ahead and save this post so you can watch it later. But I want you to go into the court portal, or when you get a chance, go down to the courthouse and download the proof of service or the affidavit of service in your case. If you can't find it, that's a red flag. If the address is wrong, that's a red flag. Any one of these things can have your child support case considered void. And in episode 3, I'm going to show you the exact way that the child support system manipulates.
You've received notice from the agency. That's sufficient. Why won't you simply proceed?
Notice from an agency does not substitute proper service.